Good evening. I'd like to welcome you to the Taubman Center for American Politics and Policy at Brown University. I'm Richard Arenberg, visiting professor of the practice of political science and a senior fellow at the Watson Institute for International and Public Affairs. I'm honored to serve this year as interim director of the Taubman Center, which is a part of the Watson Institute. Welcome to the many Brown students, faculty, and alumni, and other interested citizens joining us virtually tonight. The Taubman Center seeks to influence American politics and policy through scholarship, public opinion polling, conferences, workshops, academic research, internships, and a robust series of speakers drawn from experts, the media, academia, think tanks, and public officials. The Taubman Center for several years has focused its efforts on three themes: the pursuit of security, the cost of living, and challenges to our democracy in America. This year, we are placing special emphasis on the national elections and the subsequent consequences as the nation grapples with issues of social justice, public health, education, the economy, and commitment to the rule of law, with a roster of outstanding speakers and programs. Tonight, we focus on an exciting new book, Trump, the Administrative Presidency and Federalism, written by Professors Frank J. Thompson, Kenneth K. Wong, and Barry G. Robin. Frank Thompson is Board of Governors Distinguished Professor at the School of Public Affairs and Administration and the Center for State Health Policy at Rutgers University. He has published extensively on issues of health policy with particular attention to the impact of federalism. His most recent book is Medicaid Politics, Federalism, Policy Durability, and Health Reform. He is a fellow of the National Academy of Public Administration. Barry Rabe is J. Ira and Nikki Harris Family Professor of Public Policy at the Gerald R. Ford School of Public Policy at the University of Michigan. He's received 4 research awards from the American Political Science Association and has published widely in the area of environmental policy and federalism. Recent books include Can We Price Carbon?, Greenhouse Governance, and State House and Greenhouse. Our colleague Kenneth Wong is the Annenberg Professor of Educational Policy, Director of Urban Education Policy Program, and Professor of Political Science, Public Policy, and Urban Studies at Brown University. He's published several books on education policy, governance, and accountability, including The Education Mayor and Funding Public Schools, Politics and Policy. In a moment, I will turn the mic over to Professor Thompson. Each of the authors will make a presentation about their book with whatever discussion among themselves they choose. At approximately 5:45, I will rejoin the discussion to raise a question or two, and at 6 o'clock, we'll entertain questions from the audience. You may enter questions through the question and answer box function, which will be viewable to me. You may begin entering questions beginning now and throughout the event. Please keep them short and to the point. I will convey as many of these questions to the panel as we have time for. This event is being recorded for later viewing, available on the Taubman Center website or the Watson Institute website. So with that, I'm pleased to welcome our authors and turn the microphone over to Professor Thompson.
Thank you very much, Richard, and it's also a great pleasure to be here at Brown, and thanks to Samantha Griffin and others, and Ken, of course, Ken Wong, my co-author that have made this possible. Is the first slide up yet? I think in the interest of time, I'm going to barrel ahead. My role in this, our division of labor, is for me to kind of introduce the framework, our focus on the administrative presidency, and then talk specifically about the Affordable Care Act. And Barry Rabe will then jump in on the climate policy, and subsequently Ken on education, and kind of wrapping up some conclusions for the book. But again, I think there'll be a slide popping up. Maybe it has and I'm not seeing it, but I'm just going to jump in. So the first slide here focuses on what I call the rise, what we call the rise of the administrative presidency. And if you think, and if you think of American history, with the coming of the New Deal, bigger government, and more recently in the current times where Congress has often been gridlocked and dysfunctional, increasing amounts of important decision-making authority have moved to the executive branch of government and its various administrative agents. Now, early scholars and observers of this trend worried that it might lead to the development of a professional bureaucratic complex that would be very difficult for elected officials to control. Indeed, Mr. Trump and his supporters often talk about the deep state, but at least in terms of the political science literature, what increasingly has been an emphasis ever since, I think, the Reagan years in particular, has been a notion that there's been a rise of the administrative presidency, by which I mean that there's an elevation of the commitment and capacity of the White House to strongly influence and shape domestic programs in the absence of any shifts in congressional legislation or congressional intervention. It's kind of about the rise then of executive branch power. Virtually, Reagan is often identified as one of the pace setters in this regard, but in the book we analyze how Bill Clinton pursued various strategies. Bush too, and indeed Obama were also pursued vigorous, aggressive administrative presidencies. But we also believe that President Trump has taken this trend toward aggressive executive action toward new levels, and we try to demonstrate that in in three policy areas. A focus on the Affordable Care Act, a focus on education, and a focus on climate science. Okay, yeah, there they are. And the other contextual theme here is that we're focusing on the administrative presidency in the context of a hostile takeover, where the White House, a new president comes in who has values inimical to the fundamental goals of many of the agencies we're studying, and also is very unsympathetic to the what happened under the under the Obama administration in this case. So in broaching this topic, we address 5 key questions. Again, a slide is going to pop. There we go. So I won't have to go over them. Basically, if you look at those 5 questions up there, they kind of fall in a quick sense. Need to get my watch out here to make sure I keep track of the time. can be summarized pretty quickly. One is, what were the goals of the administration? The second one is about what kind of executive branch strategies and tools were used. The third one is about whether it succeeded, whether for all the effort and the tools the president have, whether he transformed policy in the way that he intended. The fourth one is kind of an implications. What do we know about any effects on insurance coverage over the health insurance coverage over the first 3 years of Trump, educational testing and achievement, condition of the climate, and so forth. And the last and fifth question, which we address in the final chapter, is what does this teach us about the ability of the forces of federalism to act, to foster democracy, and in this case, to act as a check on executive branch power at a time when Congress has often, at least in our view, failed in that role. So let me turn now to the Affordable Care Act. And I want to spend just a moment, as you see from the first bullet on there, we're using the term sabotage, which many partisans of all kinds have used and pundits of all kinds have used to describe Trump's stance toward the Affordable Care Act. But we use that because we're political scientists and want to be analytic. We did not rush to use that term. After all, presidents, virtually every president comes into office favoring, certain programs and not being very interested in others. And often what a president does is he arranges resource reductions, pressure on an agency to de-emphasize certain goals, directives to alter their administrative approach, and other things that often undermine the effectiveness of a given program. And frequently it is done under the name of, oh, we're modernizing the program or making it better. So there's a whole, group of programs where that fits. But ultimately we wound up agreeing with the partisans and the pundits that sabotage was the appropriate term to use in this case. And it's a very rare instance, we believe, in the context of the administrative presidency. And just to quote Webster to give you a feel for it, sabotage refers to efforts to foster destruction or obstruction of a certain topic. It connotes a basic effort to cause the failure of something. And in our view, and in the context of the administrative presidency, that's what the Trump administration has attempted to do. And it kind of, in the Constitution, there is this provision that the president take care that the laws be faithfully executed, and sabotage comes about as close as you're ever going to get to making a case that a president doesn't meet that requirement. Okay, so let me get moving. Any event, the last two bullets just bring you up to date. The Affordable Care Act cut the rate, the number of uninsured appreciably from roughly 15.5, 16% down to 9%. When Trump came in, they tried to repeal the law, and their efforts did more to bolster the popularity of the Affordable Care Act than anything the Democrats had done in the prior 6 years. But they did manage to repeal the tax penalty associated with for not having health insurance. So if I can get the next slide. This, we go into real detail in the book, and I've got, by my reckoning, about 6 minutes to get to the end of this talk. So you feel free to ask questions in the obviously Q&A period, but this is going to be a once over likely. So just looking at these bulleted items, one of the things that Obama wanted to do, and what is the key to health insurance and keeping premiums down, is to get healthy people, part of the people buying and participating in health insurance programs. And so Obama went to great length in the case of the insurance exchanges, which are a key provision of the Affordable Care Act, these state-based exchanges where individuals or small groups can go to buy insurance. He made considerable effort to advertise the fact that you could go to these exchanges, and if your income was from 100 to 400% of poverty, you could get the federal government to subsidize your purchase. Trump cut the enrollment period in these exchanges in half, and he also greatly reduced the advertising effort. The second point refers to the fact that for these exchanges to succeed, you had to coax insurance companies to participate in them. And the idea was the more the merrier, because if you got more insurance companies in it, people hoped there would be competition among insurance companies holding premiums down. It would give consumers choice among different insurance plans. And so subsidies were provided, and this is really arcane and I'm just not going to go into it, but subsidies were provided to insurance companies to participate. And what the Trump administration in concert with Republicans in Congress did was basically to eliminate them, therefore increasing pressures on insurance companies to increase insurance premiums and not to participate in the exchanges. The third bullet refers to the fact that the Affordable Care Act tried to increase the quality of insurance in several ways, but let me just mention three. One was that it assured that all insurance would cover 10 essential health benefits: maternity care, mental health. Another was protection for those with pre-existing conditions. People, 27% of the American populace with pre-existing conditions could get health care at a reasonable cost. And the third thing was to prevent medical bankruptcy by preventing insurance companies from cutting off subsidies once you ran up a big medical bill. So what Trump did, and I can't possibly get into this, is to create, through short-term health insurance and ERISA-based association health plans, ways people could buy cheaper and much less quality insurance, siphoning off people from the insurance exchanges and therefore putting upward pressure on premiums. The fourth bullet there is waivers. Both Medicaid demonstration waivers and a special waiver authority under the Affordable Care Act were used with initiatives to discourage enrollments. Probably the most widely noticed of these were Medicaid waivers that allowed states to impose work requirements and a whole set of administrative burdens on Medicaid enrollees who wanted to be covered. The Medicaid expansion covered people up to 100 working age adults under 138% of poverty. The final one, the fifth one was the Department of Homeland Security initiative made it clear that if you're a legal alien in this country, a legal resident who wants to apply for a continuation of status or improve your status as an immigrant, it would be held against you if you ever subscribe to enrolled in the Medicaid program. And the final issue, which has been much in the news, sabotage initiative, which has been much in the news recently, is the effort by the Trump administration not to defend the challenge to it in court. I'm getting very low on time, but Ken, just pose the last one, and this will be very, very quick. Bottom line is that to this point, the sabotage initiatives have been thwarted by the forces of federalism, the courts, and some other suits by a private party. I could go over each of the first 5 initiatives and say, yeah, there's been some dip in enrollment, a slight uptick in uninsurance rates. But by and large, for all the furor, the forces of federalism and combined with some others, have been very potent in resisting the sabotage initiatives. The big issue, however, is, as you know from the news coming up, the Supreme Court on November 10th will hear yet another case which challenges the fundamental constitutionality of the Affordable Care Act, brought by Republican state officials, 18 Republican state attorney generals, to a go-to judge for conservative causes in Texas that has made it through the Court of Appeals and is now before the Supreme Court. The recent attention on this has been focused, of course, and I'll conclude with this, on the passing of Justice Ginsburg, who was a supporter of the ACA, and the nomination of Amy Barrett, who has written several articles which are highly critical of earlier court decisions, which essentially allowed the ACA to continue to exist. So I'll conclude there.
Well, thank you, Frank, and please allow me to begin by also thanking Ken, Richard, Sam, and our friends and colleagues from Brown who have helped make this possible. It's really great to have this opportunity to be together today talking about this. Now, Frank very ably described what happens in a case like this where major new legislation is passed by the preceding president, and in terms of a response, much of the focus of that president is trying to do everything possible to the succeeding president to weaken or sabotage. In the climate area, it is interesting because some of the very language Frank was employing a moment ago, including nuclear option, was discussed within the circles, the early circles of the Trump administration as a possible reaction, where you might have envisioned an early act of Congress or an early administrative act that in one shot, the nuclear option as it was called, would try to take out everything Barack Obama had tried to do during his 8 years as president on the issue of climate change, even though Obama never was able to sign a major bill into law, but yet took on major initiatives. And so I call this search and destroy, a military strategy really first developed fully in the Vietnam War, which involves not the one-time takeout of an opponent, but a series of structural surgical strikes, the goal of which is to weaken or destroy that initiative as much as possible and reduce the chances that it would come back again. And so I describe the Trump approach from the administrative presidency as a type of search and destroy in climate policy. And this builds on the fact that it has been a long, long time since any president working with any Congress signed into law either a major reauthorization of the Clean Air Act, as evident in this case, clean water legislation, or any other major statute related to the environment, much less a climate bill, which has never been adopted. Now, this seems like long time ago history. This is George H.W. Bush signing into law the 1990, where were you all in 1990, all the people in the audience, the Clean Air Act amendments. An amazing cross-partisan agreement, which, interesting to have learned, Richard, our distinguished host, formerly worked with one of the congressional architects of this, Maine's George Mitchell, came together a comprehensive overhaul of the Clean Air Act, but decided, even though climate change was emerging on the agenda, and George H.W. Bush, running for the presidency in 1988, said if elected, he wanted to bring the White House effect to the greenhouse effect. This program never expressly dealt with climate. You don't find the words carbon dioxide, for example, anywhere in the 300 plus pages. So any activity between Bush and Obama on climate really federally involved acts of Presidents Clinton, President Bush, but largely incremental in nature. This is not the kind of presidency that Barack Obama envisioned. He campaigned on a market-based carbon system known as cap and trade, which drew out of a specific title in the 1990 Clean Air Act provisions that were applied not to carbon dioxide and climate concerns, but sulfur dioxide, and developed that. And in his very first speech to Congress as president, there's an important and lengthy section asking Congress to send me a carbon cap and trade bill that he anticipated and many people were expecting would indeed be signed, that this would be a far-reaching new strike for the country. It never happened. And ironically enough, at about the time the House of Representatives was passing what is now known as the Waxman-Markey legislation, which would have set up that kind of a system now 11 years ago, the president simultaneously began to pivot. And while he kept his legislative channels open, simultaneously decided to go the administrative presidency route, literally going back to the document that was signed into law in 1990 by George H.W. Bush, and looking strategically at each area of carbon or methane emissions that contribute to climate change, and looking at which section or provision or policy tool, all of which are different in this big sprawling bill, might be applicable to those issues. And in each area, in each case, initiated an administrative presidency process. The Clean Power Plan, designed to put a cap over national emissions from the electricity sector. Issues concerning methane, gas operations, even solid waste landfills. It got into that level of development, but also the transportation sector, tailpipe emissions. What's particularly significant about this area, and for that matter, this photo, this is a historic moment in the Rose Garden of the White House in May of 2009, only 3 months after that speech. And in it, you will not expand and do a 360 panoramic view. You will not find many members of Congress. Congress did not have its fingerprints on this. But what this involves is a relatively new president taking incredibly bold administrative presidency action, taking a key provision of the Clean Air Act that does give considerable power initially to the state of California and has historically, and administratively merging that, kind of a shotgun marriage, with federal fuel economy standards, which has been around for a long time, but expressly restricts any role from the state. Brings these things together, and the deal is being struck not with members of Congress, not signing into law new legislation, but among other things, the Republican governor of California and the Democratic governor of my current state of Michigan, who states that have never seen eye to eye on this issue, but are being brought together under a really remarkable, unusual circumstance. And so you can even go back to the Obama presidency here and not see a lightning strike like the Affordable Care Act that Frank was talking about, but in this case, a multifaceted approach to use these powers, each of it involving different mechanisms and tools, and each of which had different relationships with federalism and the states, and really beginning to set that up. There's also then a global or an international side of this case in ways that probably doesn't emerge as much in the healthcare case or the educational policy case, and that is the foreign policy or international dimensions of this. Here again, Obama moved aggressively through use of powers that he had, knowing that if he were to sign a treaty like the ill-fated Kyoto Protocol, if he were to try to take that back to the Senate, say for approval, he had no chance politically to do that. Instead, he embraced the idea of executive agreements, a weaker, softer, more flexible tool available to presidents, and the entire Paris Climate Accord, which was ratified or agreed to in 2015 globally, was set up internationally because our international partners knew that Barack Obama wanted to do this, but had a problem known as Congress, and realistically could not get a treaty through. And so the entire Paris process, long before Donald Trump entered in the scene and pulled us out, President Obama put us in and created a non-binding national reduction pledge, adding up not comprehensive legislation because it wasn't happening, it wasn't going to happen, but if you would sum up everything that might have happened in the electricity sector and these other sectors through executive action, and adding up what a number of states, including especially those on the coast, were doing, you could technically add that up and create a pledge that would be acceptable. And this approach was tried in other areas. Methane, this hugely important greenhouse gas that is often under examined. You saw the picture a moment ago between the President Obama, Prime Minister Trudeau, and former President Pena agreeing to, this is called the Three Amigos Pact, that agreed to nearly a 50% reduction in methane from the oil and gas sectors from each of these three North American continental neighbors over a period of really a relatively short period of time. Again, an executive agreement without congressional fingerprints on it, but also big ramifications for states in terms of implementation. Now, next slide, please, Ken. Thank you. This then sets up Mr. Trump and what he does. And again, no nuclear option. One could envision a statute, especially when Mr. Trump had significant Republican numbers in the House and Senate, to eviscerate any climate considerations through an amendment to the Clean Air Act. Was not tried, or other strategies that might have done this. There was no direct assault on the so-called endangerment finding. The Supreme Court's classic decision, landmark decision in 2007, a case brought by Massachusetts and a number of states to force the hand of EPA to begin to acknowledge the concerns over climate science and climate-related risks. That was not taken on as a frontal assault by the Trump administration. And yet the president had made commitments to move in some of these areas, much of this linked to his embrace of coal. And so what emerges throughout the Trump presidency, and is literally playing out to the last days of this term, is what I would describe as a systematic search and destroy effort to both eviscerate in some cases, or to repeal, or to reverse, or delay, different tactic depending upon the particular policy subfield we are talking about, and to attack everything his predecessor had done, largely through administrative action, and to respond to that and try to level it or destroy it or minimize it also through administrative action. So an interesting sort of pair of presidencies here, and to see that response. And then of course in the Trump case, replacing that to the extent anything had to be replaced with the weakest, mildest kind of constraint on greenhouse gas emissions imaginable. And of course, one of the themes that emerges for us in all of these cases, and Frank has talked about this already in the healthcare case, Ken will be talking about this momentarily, is what this triggers. Not reactions from Congress other than hearings and occasional expressions of concern, but ferocious state response, aggressive litigation coming from attorneys general, Democrats from New York and California, but a great many other states where Democrats hold that elected office at the state level. But also lots of new state policy. Within days of President Trump removing the United States from Paris, the "We're Still In" movement begins for states to actually pledge unilaterally to try to meet Paris targets within their own borders and boundaries. And so what this does is, nearly 4 years now into the Trump presidency, is it reflects a kind of intergovernmental collision between how far can a president go using these powers and strong pushback in the courts, but through their own ability to develop policy sub-federally, at least a good number of states. What this means is a lot of uncertainty, a lot of delays, a lot of things that are going to be hanging, including the Paris Agreement, which still can't be withdrawn until the days after the election and could be easily reversed. Many of these other policies and procedures would be harder to manage and harder to pivot quickly. Many of them faced significant setbacks in the courts, delays. Many of these are still in process. There are lots of T's being crossed and I's being dotted on regulatory provisions, perhaps until the last hours of this administration, but will clearly leave it much harder for any Trump successor to simply pivot and reverse and restore the Obama provisions. Finally, as did Frank, I would only note the passing of Justice Ginsburg, with potentially substantial impacts for all of this, climate, but also water and air policy, because of far-reaching expectations of possible changes in the court, assuming Justice Barrett joins a majority that may already exist, to rethink administrative law and rethink major decisions related to the powers of agencies like EPA to really be guided by presidential action. To be determined, but even in the last days, we continue to see all of this play out with some real uncertainties about the future of this approach. And with that, I'm happy to turn things over to my colleague, Ken Wong.
Great, thanks, Barry. Thanks, Richard, for inviting us to give this job talk. And the benefit of really doing the cross-policy analysis is that we are able to compare across different settings and different institutional constraints and conditions and politics, of course. So when we look at the three policy arenas, the sabotage that Trump has initiated clearly has the widest magnitude in the case of ACA in healthcare arena. And then somewhat moderate and strategic, like Barry was talking about the search and destroy strategy in the climate policy area. And in the case of education, is comparatively modest, in part because when Trump started his presidency a couple of years before, there was a bipartisan agreement on the general framework that governs federal involvement in K-12 education, and that is the passage of the Every Child Succeeds Act. And it has a lot of Republican support as well as overwhelming Democratic support. And that act actually framed the idea that the federal role has overextended itself and that they need to scale back to allow more state control over curriculum, as well as school improvement initiative. And Trump generally signed on to that philosophy as an anchor for engaging in K-12 education policy. But at the same time, Trump also brought with him a wide range of ideological commitment, and particularly in terms of rethinking the role of federal government in supporting student rights, civil rights, federal oversight on important areas that, including a lot of federal spendings in all kinds of categorical initiative, as well as in higher education that the Trump administration has always been thinking about ways to engage in ways that would redefine, the role of the federal government in higher education initiative. So the way that we look at federal education involvement during the Trump administration is that the fundamental mechanisms are quite similar to the other two policy arenas that we just heard. And that is, under some conditions, Trump administration would empower state and local government to take more initiative. And then at the same time, under certain circumstances, Trump administration would try to constrain constrain state and local initiatives to serve the Trump administration's ideological position. So I'm going to give you some examples of that in the education policy arena. And so basically what we have is that the whole objective of the Trump administration in education is to rescind as much as they could a lot of the Obama rules and regulations that govern equal education opportunity, as well as civil rights enforcement and accountability. And at the same time, the Trump administration is trying to rescind the Obama rules and regulations that govern for-profit organizations in terms of engaging in education services. So one key example is the rollback of Office for Civil Rights data collection. So since 1968, OCR has initiated biannual data collection elements that require state and local agencies to comply. But because of the Trump administration, since 2018, a lot of those data requirements have been rolled back. And so here in the slide, a couple of bullets, I highlighted that the Trump administration has rolled back on subgroup categorization of data in a range of areas. And then the Trump administration also give a lot more flexibility to districts and schools in submitting data on a wide range of issues. For example, computer science classes representation, student representation, those classes disaggregated by race, gender, and disability. as well as connectivity, accessibility across classrooms. And that's a very important, the reason why I mentioned those two is because those are the key issues right now in the kind of the pandemic era. And then the second major area is to roll back on the Obama era on systemic bias investigation. And that is a very important commitment on the part of the Obama administration. But in the last several years, because of the Trump rollback, we have witnessed a lot of closure, a lot of termination and settlement of cases. So for example, in 2017, there were over 17,700 cases closed. And then in 2018, another 14,000 civil rights cases settled by the Trump administration. And that's a big jump of settlement and case closure compared to the Obama administration. And then the Trump administration also rolled back on a lot of guidance documents affecting children with disabilities, including a lot of critical information on IDEA funding use that would benefit IDEA, special needs children and their family in terms of how to talk to the teachers and how to talk to schools in terms of their rights and access to federal funds. And finally, the Trump administration also significantly redesigned the campus sexual misconduct investigation and also broadening the opportunities for complaint, the people who are allegedly committed sexual misconduct to grant them broader set of rights in terms of challenging the alleged victims. The next area of Trump rolling back or scaling back is the area of federal oversight on critical federal investment, particularly in education that support low-performing and low-income students. And that's what we call the Title I program. And one of the critical oversight rule is the supplement, non-supplant. And that has been in the federal Code of Federal Regulation since 1968. And so the idea of the Trump administration was to give maximum flexibility to districts and states and schools so that they could use the federal categorical funds more flexibly, regardless of the status of the Title I designated schools. So that's a big departure, not only from the Obama administration, but from all the administrations since 1968 in terms of making sure that federal funding are used for eligible targeted activities and populations. And the Trump administration also loosened up a lot of the regulations that govern for-profit organization engagement in post-secondary education arena. So one of the area is a gainful employment rule where former Secretary of Education Arne Duncan worked really hard to make sure that all the for-profit organizations would, would make transparent in terms of the student debt to earnings ratio. And that is no longer the case. And the current Secretary of Education significantly revised the required profile in terms of gainful employment rule. And finally, the Trump administration also significantly reduced the rights of the student loan borrowers, even when the financial institutions were found to have engaged in fraudulent or abusive financial practices. So for one thing, the Trump administration, very interestingly and quite disturbingly, eliminated the Consumer Financial Protection Division within the OMB. And so there is no longer a memorandum of data sharing agreement between the Financial Protection Agency and the Department of Education so that they could actually track some of the data affecting student borrowing practices. And so there have been a lot of going back and forth and including congressional investigation on this particular topic. To what extent should the federal government continue to protect the civil rights, the student rights of the student borrowers, even when the financial institution engage in fraudulent practices? But the Trump administration has significantly weakened those kind of rules. And finally, with regard to the implementation of Every Student Succeeds Act, the Trump administration has basically taken a broadly deference policy to allow states to come up with their own priorities, their own plans, even though the law itself, of course, will try to limit the direct intervention on the part of federal government in ESSA implementation. But nonetheless, there is still a lot of important responsibility that federal government needs to perform, including auditing and federal oversight. But nonetheless, the Trump administration has tried to take a more permissive role as much as they can, to the extent that they basically just put a rubber stamp on basically all the ESSA plan that come through their desk. And in addition to that, they became a lot more permissive in terms of state proposal not in full compliance with disaggregation of student performance data. So I think that would have some broad implication in terms of tracking schooling opportunity and racial and income achievement gap in the future. So the big picture that this book tries to capture is that toward the end of the Trump administration in the first 3.5 years, what we found is that even though there were a lot of aggressive administrative executive actions and legal initiative directed at each of these policy arenas, the consequences have been mixed, as my colleagues just pointed out. And why is that the case? Why were so many delays and challenges? And so we would like to call to your attention on one of the key arguments in the book, and that is forces of federalism really matters. And one of our colleagues, a political scientist, John Kincaid, he mentioned that, well, federalism is a consolation prize to parties that do not control the presidency. That is, they can still, they earn the legitimacy and continue to be able to air the voice, their concern, their dissent on policy and challenge, provide some check and balances. The three of us feel that this actually can be stretched a little bit to the next level. And that is just, they are not only just a consolation prize, they provide meaningful and purposeful, sustaining sources of resistance to the party in charge in the White House. And that comes out loud and clear in the case of the Trump administration. And in particular, we zero in on the role of the attorneys general across all 50 states. And in the last 20 years, we know that governors, of course, they would lead the opposition. I mean, we already seen that COVID-19, we've seen Governor Cuomo, governor in other Democratic states, Democratic governors, they took the leadership to actually challenge the Trump administration. But at the same time, what have not been as highlighted by a lot of researchers are the role of the AGs, the attorneys general. And in the last 20 years, the AGs have organized themselves in a formidable coalition. So right now we are seeing two formal coalitions in the making, and they're playing an important role. One is the Democratic Association of Attorneys General, and the other one is the Republican. And Frank mentioned earlier that the Democratic coalition of AGs have actually generated the litigation that now will be in front of the Supreme Court the week following, I think November 10th, in front of the Supreme Court to revisit the constitutionality of ACA. And at the same time, what we are seeing is that on the resistance side, Democratic AGs have been quite organized in challenging the Trump administration in each of the three arenas. So in this and the next two slides, I highlighted some of the examples here where the AGs from the Democratic side are actually stepping up, and they play a very important role in healthcare policy. They actually are trying to defend the federal law. So when when Trump's Department of Justice decided not to defend ACA, the Democratic AGs organized themselves to came forward and try to defend the ACA, the federal law. So that's very interesting development. In the case of climate control, we see a lot of, under the leadership of the Attorney General in California, we see a coalition of AGs work together to really continue to support and provide the legitimacy on the California exceptions in terms of emissions policy, as well as a whole bunch of other climate control policy. And in the case of education, the AGs came together and really protect the consumer's right, the students' borrowing right, and challenge the for-profit organizations in terms of their financial obligation and practices. And as Frank and Barry pointed out, actually a lot of the AGs spearheaded to develop legislation in this area to protect student borrowing rights. So all of these will gravitate toward November and beyond, of course. And so what we believe is that if Trump wins, what we are going to see is continuous sabotage, continuous search and destruction, and continued dismantling, rollback of civil rights and student rights, protection of for-profit organizations and agencies in delivering higher education services, and rolling back and maybe even dismantling ACA as a whole in the next few years. But at the same time, if Biden wins, we will see gradual rolling back, not right away, because we were talking about the tedious process and meeting the process of meeting the Administrative Procedure Act requirement in rolling back some of these guidance and regulations over the years. So it might take some time for a new Biden administration to actually roll back what Trump has already set up to do. But regardless of who the winner is, the three of us believe that forces of federalism in the courts and leadership at the state and local level will continue to play important checks on presidential power in our democracy. And so here is one possible scenario in January that we can imagine. And as Frank said, we actually went through a lot of details in each of the case studies. And if you are interested in the details, I encourage you to read the book. Thank you.
Well, thank you all to all three of you for a really fascinating presentation and for really a very important book that I think clearly makes a contribution to our understanding of the evolution of the presidency and the relationship of the president with through federalism with the 50 states. I wanted to start by asking you a question. I think Frank touched on it right at the very outset, but in the conclusion to your book, you write about the dangers of democracy posed by the administrative presidency. It seems to be that this connects with growing concerns about the future of democracy, which arise from the breaking of many norms by this current administration and by the threats to elections, the stability of the election process itself. You write, quote, The Trump administration, administrative presidency, vividly illustrates how political principles, rather than the administrative agents, can threaten a democracy. This is, it seems, the deep state turned on its head. I'm wondering how much each of you believes this particular concern worrisome.
Maybe I can jump in and Barry and Ken can do. I think it is very worrisome, and in political science, the traditional political science literature worries about administrators going rogue, not doing what Congress and the laws want, not doing what the president wants. But I think and especially with this administration, which is kind of the administrative presidency on steroids, with great disregard for law, in my judgment. The chief, ironically, some of the chief upholders of the rule of law are people embedded in the administrative state who actually have a strong commitment to the public ethos and care when they're asked to do something that does push the law into another realm of even beyond the most liberal court interpretation being acceptable. So in a certain, we've turned the conventional concern, rogue bureaucracy, administrators running rampant, on its head. And I really do believe that I teach in a public affairs and administration program, but I really do believe that civil servants, professionals in the bureaucracy are in some ways key defenders of democracy and the rule of law in the current context. That's my take on it.
I spent 34 years on Capitol Hill, and I always felt that the federal bureaucracy got a bum rap.
Mm-hmm.
It's kind of easy to dump on bureaucracy. Nobody likes it very much. It's a lot of red tape and so forth.
Right.
But really, the federal agencies are just chock full of professional, patriotic people who do really outstanding work in so many areas.
Mm-hmm.
And I think you're right. In this current context, they're one of the institutions in our government which is helping to protect our democracy. Barry and Ken, did you?
Yeah, related to that, I briefly mentioned the APA Act of 1946. And I keep wondering, and when I was doing the research with Frank and Barry, we learned so much, not only in terms of from the political science perspective, but also from the administrative law perspective. Mm-hmm. And that is that when we attack the bureaucracy, the way that I see the Trump administration, when they attack the bureaucracy, they also call into question this whole system of administrative law and rule of law that Frank talked about, the guidance, the procedure through which we need to go through in order to justify important administrative shift. So the APA provided a tremendous amount of credibility in this process right now. So the reason why we are seeing so much success in pushing back some of the Trump initiative is because of the APA. So every time the district judge would say that, well, this arbitrary, you didn't even write a memo to attach to why you want to dismantle these guidelines. Go back and do your homework and do your data analysis, come back with a memo. This is what the APA requires you to do.
I would only add that I really share these concerns. And I have really wondered I will say the environmental case, not APA, but EPA, what happens when the pressures of administrative presidency are so great, they can almost be seen as an effort to crack or break an agency, quite aside from climate in the water and air arenas. I would argue, I think there's substantial empirical evidence. The Clean Air Acts, the versions of the 1980s, but the 1990 legislation of which I spoke, is really a major legislative achievement, but it's also a major accomplishment by the folks who work at EPA, interpret it and apply it to all of these areas over the last 30 years. Huge, huge gains in many areas of air quality protection. And I think one can begin to see, especially with denigration of science, adding political layers and restricting the ability of people with expertise as an agency to speak, to have access to the process, to be walled off because of political channels, is deeply concerning in a number of areas, but especially the EPA piece, which would just have to be a mainstream of any significant effort that one could envision that the US would attempt in the climate arena over the next decade or more.
Let me ask one more question and then I'll get out of the way. We've got some audience questions building up. But I wanted to ask you about the Congressional Review Act. Republicans and the Trump administration used the joint resolution of disapproval under the Congressional Review Act, which, as I recall, was passed in 1996, I think, to overturn 16 rules at the very outset of the Trump administration. This was, going all the way back to 1996, the Congressional Review Act had only been used one time in its history, and the Trump administration came in, it was used quickly 16 times. This is a powerful tool because if a joint resolution of disapproval is enacted, this not only repeals the rule, but also requires that in order for the rule to be reinstated in substantially the same form, this requires an act of Congress. Mm-hmm. So it's a pretty strong tool. Now that it's only a 60-day window, and so this situation is likely to come up primarily when one administration replaces another of the other party, and mm-hmm. there are rules that have been pending and that are very often administrations on their way out the door also like to pass a lot of rules when they realize that the time is running out on their administration. And so then this is a tool which incoming administrations. I guess I wanted to ask you how useful you think this turned out to be for the Trump administration, and does it have a major role going forward?
Yeah, this is particularly important in education because I found a memo on the first day of the Trump administration. The chief of staff sent a memo to all the agencies and asking them to first stop issuing any new guidance or any administrative rules. And then immediately then, the next day, there was another memo that I found that kind of communicated his idea with the congressional allies. And because of that, within a week, then they come and formulated this CRA. And in education, it is very important because shortly before the end of the Obama administration, the Secretary of Education, John King at the time, worked very hard in terms of kind of stipulating what are some of the rules and regulations that need to go with the every student succeed at in order for the state to comply. And so they built in a lot of conditions. And those regs were totally gone because of the CRA resolution. And so, and your comment about that in the future, if they want to revisit that, if we have a Biden administration, if they want to revisit some of these conditions, they will need the act of Congress to do it. It's not as easy.
Right.
So at least in the CRA now, we have a little more empirical evidence over the last 3.5 or 4 years than we did before over the political strategy under which this might or might not be used. There actually was quite a bit of CRA activity in the environmental arena, although more of it was focused in the areas of mining and interior department rather than EPA. And there was one near successful use of it, but it was blocked by John McCain at the last minute, reversing a decision on methane issues. But you do run into issues. As you noted, Richard, the clock is really tight. You only get so many days early in a new presidency if you want to use it. And of course, as we all know, it's awfully hard to get any legislation through. And if you're going guess what, in those first 60 or 90 days. So you actually have competition for amount of time that has to be spent on the floor. Congress really needs to know what it's doing. They've got to be really surgical and go after this systematically. Will leave lots of room for time that could be spent moving a legislative agenda. So there are real challenges and impediments to this. Much as Ken is noting, questions about whether this could emerge under a future Biden presidency, but with all the same stipulations and constraints in place.
Right. I think they've summed it up real well. I would say, just looking at the Trump administration, indeed issued some major federal regulations affecting, under the Administrative Procedure Act, affecting the ACA, but there's been nothing in I think the 60-day window that Biden and, if the Democrats do well, could counteract.
Okay, let's turn to our audience. And the first question from a student is, what can we expect in terms of executive action from either Trump moving forward or Joe Biden if he's elected?
Well, I'll take the first whack and won't go on at great length. But, I think in almost all the areas, we could expect Biden to set about reversing, especially the Affordable Care Act, which I've watched most closely, set about reversing them. Once you, however, put a federal regulation in the books, as you well know, it takes work to take it off. Other actions, say in the case of waivers in the Affordable Care Act, administrations can come in and change waiver policy pretty much on a dime. The work requirement waivers that Trump introduced in the case of the Affordable Care Act have basically been thrown out by the courts anyway, but if it did rise again, they could greatly reduce, they don't have to accept these waivers that have the effect of depressing enrollments. Of course, the big issue in the ACA, if in fact the Supreme Court throws the entire law out, then you're starting from scratch. Then Trump really scored a major victory. And I'll wrap up here. If Trump wins, and if the court doesn't throw out the ACA, and the decision by a federal district court doing this has been panned by legal experts and pundits from across the political spectrum, but live and learn. Then I think they're going to have a hard time making much headway on their initiatives, these sabotage initiatives. The Supreme Court has already issued a decision telling them they can't cut off funds from insurance companies, and I think if the court, if the ACA can survive the Supreme Court, I don't think the other Trump initiatives are going to be that potent. Maybe with a few acceptable court rulings, but I think the ACA will be hard to beat down if it can survive the existential threat.
I think it's worth pointing out, you've illuminated very much the role of federalism in resisting the growing administrative federal presidency. But a corollary to that, it seems to me, is the growing role of the judicial branch, at the federal level.
It
And,
sure is.
and it's in the nature of these kinds of shifts of power that once they shift, it's very hard to move them back.
I think that's a good point. Excellent point.
It appears, this is again a question from the audience, it appears that the top 8 presidents to use executive orders in order by the number they executed annually are as follows: FDR, Hoover, Woodrow Wilson, Warren Harding, Calvin Coolidge, William Howard Taft, Teddy Roosevelt, Harry Truman. Only one of those, and just barely, served within the past 70 years. What is different in the way you are seeing modern presidents use the executive order that leads you to conclude that they're leading a more administrative executive branch?
Want me to take a first swing at that, Barry or Ken, or do you want to bet first? Okay. First of all, you have to keep in mind that executive orders are issued on everything from the most trivial kinds of things, announcing something to something big and very important. So it's a good point, and I think counting executive orders is interesting. But you have to look at whether they're more important. The other thing I would just underscore is, the chapter in education and Barry's chapter and mine deal with it. Executive orders are an important tool in the presidential array of things, but the tools used by the administrative presidency, many informal tools, I would argue, are equally important, or just launching new federal rules under the Administrative Procedure Act. Just to I don't know if you want to comment, Ken, but under the Obama administration, for instance, there was a radical change, well, I won't say that, a significant change in the way sexual harassment issues were dealt with in institutions of higher education. And they were almost all done by someone issuing a guidance document. No, big executive orders, no formal rulemaking. So that's a fascinating point. I may go back and look at what Warren Harding actually did, but I think executive orders are a limited indicator of it. And I don't know, Barry and Ken, you might want to pick it up in your areas.
Yeah, I just want to ditto that, underscore that, because if you look at K-12, right, elementary and secondary education, there's one major executive order under Trump, and that is 13791. Issued in April 2017. And all Trump needs is that executive order because it's so encompassing. That language is so systemic in its nature, really give state rights the new legitimacy in defining education policy. So you don't need 1,000 executive order, you only need that one. And that kind of trigger everything, right? Mm-hmm. So that's one. The other thing that I'm just thinking is that in higher education, Frank, you mentioned the federal rulemaking, and that is one additional mechanism. And we also have waivers. We have legal, we could be friends of the court, amicus brief, and things like that. So there are all kinds. So in other words, in our book, we not only examine executive order, we also examine all these wide range of administrative and political and executive strategies that kind of constitute the whole system of the Trump overall approach in his administrative presidency.
I think that's right. I almost think what we need to do for executive orders, because I've noticed a tendency in a lot of the scholarship on executive orders, is literally to count and then look at patterns and trends over time, which is totally understandable. But I'm mindful that when at legislation, this has been true for decades, we look at landmark or really milestone achievements. There, I think if we would look across the 3 chapters, we would see a few major executive orders, others that are more symbolic or passing, and exactly as Ken suggests, I think this is one of the real intriguing things for me to work with my colleagues across the course of this project, is to realize how many possible tools there are when we talk about administrative presidency, including waivers, which sounds like this, wonky, boring topic, and yet plays out in each of these areas and is a hugely important policy tool, theoretically within the reach of a president at any point in time.
And I would add, I can recall that there was a sensitivity in the Obama administration because he was receiving a lot of criticism of his use of the executive order to kind of shift as much as they could to other executive actions so as not to run that total up. So
that's right.
Say he'd done it less than George Bush, for example.
Exactly.
Mm-hmm. Mm-hmm.
Great point.
Okay, for Professor Wong, I wonder if you've considered how the Trump presidency has affected efforts to establish a federal role in education. Do you think that by perhaps strategically posting an incompetent Secretary of Education, did the Trump administration shift the perceptions of the potential benefits of a federal role?
Yeah, it's a very interesting question. I would slightly turn this around a little bit and suggest that the appointment of Betsy DeVos signals to us that Trump really wants to push school choice as one of his signature education initiatives. And in fact, that seems to be the case. During the first 3.5 years of the Trump administration, what we are seeing is the saliency of the school choice in narrative. I see a lot of Republican governors now working quite closely with the Trump administration to push for some kind of scholarship to support or tax credit initiative to support private school enrollment. Even in the CARES Act, there were $180 million set aside for micro grants, and those micro grants would allow district and schools and states to use it flexibly to the extent that they would like to support non-public school enrollment, particularly online non-public school enrollment. So there are all kinds of administrative initiatives on the part of the Trump administration. So actually, and led by our current Secretary of Education, to move more toward the area of supporting not only public school choice, but also private school choice and using federal dollars.
Okay, this is also a question from a student. In your personal opinions, throughout the COVID-19 pandemic, which states have been most impacted by the relationship of President Trump to federalism, to his interaction with the states? Which have been impacted the most and why?
That's a great question, and I don't know. Truthfully, I haven't studied that. I mean, clearly there is a partisan pattern that is out there, and it's become a partisan issue with Democrats placing Democratic governors, and also the most severely afflicted at the outset, placing a premium on public health measures, and Republican governors, many of them in the Southwest, placing a premium on economic development and maybe a model more akin to Sweden. I do know that political scientists are studying that, and there have been various empirical analyses done of whether when a state imposes a lockdown, do you get, statistical analysis of this, that, and the other thing. And the studies I've read so far suggest, the lockdowns do help with, various metrics related to health. Now, a Republican would say, yeah, but how's the economy done in New York City? And I just, there haven't been enough good studies done. There are partisan differences that I just don't know the fallout of that. And the ground seems to be shifting. One day, one state looks good, or even one country looks good, and then the next day, a new wave. So it's a great question, and I don't have a good answer for you.
And the president himself has placed a kind of partisan overlay over this, in that,
Absolutely.
when he was withholding things from blue state governors and backing up red state governors. And,
Right.
so on.
And I would only add, to the extent states getting resources from the federal government, including PPE and I do wonder if studies will show that the support that the federal government was prepared to make was conditional on behavior of the governor.
Yes.
I live in Michigan, where the governor is known as that woman from Michigan. And do we just examine what Governor Whitmer and her administration have done, or do we think about that horribly strained relationship, especially when here in southeastern Michigan, near Detroit, we had a huge spike and had a very high early mortality rate. So even there, I think there is a highly politicized dimension to that. And you can also see this, and it comes up in all of our cases, this sort of cleavage between the states
Very much.
in response to who's in power in the White House.
In the preface of our book, we kind of were thinking out loud about this question, and that is whether the pandemic actually might have shifted the behavior of the Trump administrative presidency. And that is, would the Trump administrative presidency would it become more cooperative, for example? Would it continue to pursue the agenda, the ideological positions that he has taken so strongly, And what we come up with is that doesn't seem to be the case. That is, that the Trump administration continued to pursue the administrative actions that they have set out to do. They did not loosen up on the ACA challenge, even though we are talking about a pandemic, pre-existing condition. They did not loosen that up. We did not see Betsy DeVos in education to loosen up on the discussion on school choice. We didn't see that. Instead, as I mentioned, they try to use $180 million in the CARES Act to kind of support the channel, those kind of funding. And in the case of climate change, climate policy, we did not see that loosening up. Instead, there was still all kinds of negotiation and threats, sent out to California occasionally to warn them that they should not be doing this, emission standard. And so what we generally kind of come up with is that it is not going to be affected by the pandemic. That is, this pattern of administrative assertiveness and sabotage is in social policy areas not going to be affected in the conditions that we are in right now.
Okay, let me pose one last question. In thinking about the going forward, whether it's a Biden administration or another term of the Trump administration, with respect to this pattern of the state's attorneys general taking these issues to the federal courts, how much impact do you see from the ability of the Trump administration to put, for example, 53 new judges on the circuit courts, more than 200 judges on the courts overall, 3 conservative judges on the Supreme Court? It's
right. I'll take an opening whack and you guys can jump in. One of the sections of the final chapter has a heading called, that deals with this, called Partisans in Robes, ? And there's a whole political science literature which kind of two schools. One school says that on salient policy issues, you can predict how judges are going to perform based on the the party of the president who appointed them. And then you've got another school that says, well, hold on, even on salient policy issues, there are arguments that the desire for respect among colleagues, norms of legal analysis, et cetera, will mute that. And I think, just very briefly, we took a real short look at that in the book, far from a definitive statistical analysis. But I think in the environment area, or the climate area, you found all sorts of Republican judges slamming the door on a lot of things that the president wanted to do. In Ken's area, we didn't find any pattern. In the ACA area, there has been more of a tendency of, the judge appointed by a Republican president doesn't like it, and the judge appointed by a Democratic president is more sympathetic. Obviously, John Roberts and Justice Roberts and several major decisions has done that. But I think a big empirical question is, the political science people, students of judicial behavior are, Trump is banking, he calls them blue judges and red judges, and he's appointing red judges. If he's right, if they are partisans in robes, it's going to be heavy lifting for a Democratic president. But I think it's an open empirical question. I don't know, guys, what do you think?
I do think that among the kinds of questions that are likely to come forward to the judiciary, a judiciary that could look different, not just at the Supreme Court level, than what we've had over the years. For me, one interesting question that arcs across federalism is, what is the power of the state in the American federal system if the courts are moving in a much more conservative direction? And the initial reaction to that might be, well, federalism often is kind of like a conservative idea, reduce the power of the federal government and shift things to the states. But even here, ironies abound and complexities abound. I would only note the case of transportation emissions, where 53 years ago, Congress gave one state in statute power to unilaterally appeal to the federal government through a very structured process, where it's hard for the federal government to say no to California. And over 120 times, and at the end of the Obama administration, waivers were granted. Ronald Reagan asked for waivers as governor. He granted them as president. Until now, where the Trump administration is the first to take an existing waiver to California and pull it back and reverse it. That's beginning to move forward through the courts, and a Biden administration could perhaps change that, but inevitably we are going to be looking at combat with two sets of state coalitions, like don't, and it's a classic question, but with it is the question, do you give more power to government when it's a left of center government calling for far-reaching emissions controls? Is federalism an idea that doesn't matter the partisanship, there's a consistent court view on decentralization, or using the partisan robes framing that you're using, Frank, do the courts view the idea of states differently depending upon the ideology of the policy or the party with which the policy is thought when we talk about state power?
Yeah, I guess very briefly, in education, the key question is whether the court and justices are willing to address social, racial inequalities. And I think going forward, we will be seeing a lot of cases. LGBTQ, in the book, we talk about a very important case where the AGs got together and kind of protect their LGBTQ rights. And then we also have, racial as well as linguistic, cultural inequality. And so the question is, what will the red and the blue judges going to do about some of these real societal structural challenges? And it will have to be case by case. And we already know that in the case of Trump administration, they already sided with the defendants in a lot of the cases. And that is to try to not use race as an issue in admissions criteria and all the other important cases. So I think going forward, we will see a fair amount of tension. And so it brings back to our argument that the AGs become very important. They need to continue to play that role, even when the judges may not be willing to take those positions.
We're about out of time, but I want to throw one more point into the mix on that, that last discussion. And that is that we've seen an important change in the Senate in 2013 with the elimination of the filibuster on judicial nominations. And so from that point going forward, presidents no longer need to be as restrained in terms of reaching for ideological purity in their judicial nominations. And so, well, I'll leave it at that. As I say, I want to thank the three of you for really a wonderful presentation and a very stimulating discussion and a great event. And, hope to see you all soon.
Thank you so much.
Thank you.
Thanks very much. Enjoyed it.
Thank you.